Hello, everybody. It's attorney Laura Sterling, and welcome to my second live show for the month of October. In fact, I just looked at the calendar because I wanted to jog my memory about what I'm going to talk about next month. And I was so confused because I kept looking at October and going, no, I already spoke about estate planning. I already spoke about estate planning. I'm not talking about that again. And then I realized next week is November. So that was a little shocking. So I'm still trying to get over that whole realization. But can you believe it? We're on the fastest downward slide to the end of the year that you can imagine. We have Halloween next week. Then in a few weeks, we have Thanksgiving. And then, oh my goodness, in a few more weeks, we have Christmas. And then it's New Year's. And then it's January 1st. So hopefully January will bring you plenty and plenty of goodness in your heart. But anyway, today I want to talk about the remainder of this month of October, estate planning. Yes, estate planning. What does that entail? Well, my last live show, remember I spoke about a will. A will has to do, last will and testament has to do with your things and stuff, my phone, my stapler, whatever, whoever I want it to go to. It deals with my things and stuff. Living will deals with my body. What do I want done with my body when I'm unable to speak for myself? Do I want to be kept alive? Do I want to be hooked up to machines? Do I just want to be kept comfortable? That's a living will. Living will, your living body. Last will and testament, your things and stuff. And then we spoke about trust. Trusts have to do when you want something to go to somebody over time. Remember, a last will and testament has to shut down. It has to go away. It cannot stay open forever. So a trust can say, you know what? I want my nephew Jimmy to only get this certain amount now, this certain amount then, this certain amount when this happens. You can do that in a trust. So that's what we spoke about last live. This live, I'm going to talk about 3 more things. So let's start up. I'm going to start talking about a power of attorney. What is a power of attorney, you say? Well, there's 2 types of power of attorneys. There's a plain old power of attorney. My brother went to Germany to work. He wanted to sell his house. Could he do it from Germany? Nowadays he could. Back then, it wasn't so easy. So he appointed my parents to be his power of attorney just to sell the home. That's it. That's a very specific power of attorney. That power of attorney goes away when that specific task is completed. So the moment the house was sold and the signing and the closing and everything, my parents no longer had any authority to do anything. So that's a specific power of attorney. There's a second type of power of attorney, durable power of attorney. What that means is even though you become incapacitated, that power of attorney is still in effect. Now, I had a very good question from a friend of mine today, as a matter of fact, on a power of attorney. They asked, okay, does a power of attorney, durable or not, only go in effect when somebody's incapacitated? Absolutely not. It goes into effect the minute you sign it. So once my brother signed that power of attorney to have my parents sell his house, they had the authority right there. Once grandma signs that durable power of attorney, whether, later on she becomes incapacitated, that power of attorney came into effect the moment grandma signed it. So I always tell my clients that are doing power of attorneys, make sure it's somebody you trust, because you don't want somebody getting that power of attorney, friend, neighbor, maybe even family member, that takes that power of attorney, goes to the bank and cleans you out. Not a good thing. So make sure that that power of attorney that you appoint is somebody that you can trust and somebody that you've talked to about your wishes as far as how they take care of your things and stuff. A power of attorney is only valid when you're alive. When you pass away, that power of attorney passes away with you. So you can't go into the bank and say, well, I have power of attorney, and so my mother's died, and now I want to take out the funds. They're going to go, no longer. That power of attorney dies with the person who signed it. And who takes over at that moment? It would be a personal representative appointed from your will. Because remember, we spoke about in your will, last will and testament, you would appoint somebody called a personal representative that would take care of your things and stuff when you pass away. The power of attorney does not trump the personal representative. The personal representative trumps the power of attorney. So also, I'm appointed power of attorney for my mother. I cannot then say, you know what, I want to do it anymore. I'm going to appoint my brother. Here, brother, I'm signing off and you take over. No, I can't do that. My mother's the only one that can do that. So I have it on her. I say, I don't want it anymore. So you all decide what you're going to do. So, oh, good afternoon, Fabian. Love the beach. Hello, attorney. If I have a power of attorney, do I need a pre-need guardian? Fabulous question. And that's what we'll kind of segue into. Pre-need guardian. Good question, because I get this a lot. A pre-need guardian is somebody that I say that I want if I need a guardian. If I need a guardian, and we've spoken and we've done live shows about guardians before, and we will again next year. Guardian is court appointed, right? Somebody has to pass certain requirements here in the state of Florida and they become your guardian, your legal guardian. And the court has, what do I want to say? Has supervision of that guardian. And so if you have a power of attorney, you don't need a pre-need guardian. You can name a pre-need guardian for in the event maybe the person you appointed as power of attorney is unable or unwilling or has passed away or whatever, and you never appointed an alternate, or maybe the POA can't be found or nobody knows where it is and nobody can provide a copy. Then you're going to need that guardianship, that pre-need guardian. A lot of times I get people come to me and say, oh, I want my mother to do a power of attorney for me. Oh, I want my brother to do a power of attorney, all of this. But if they can't, if they can't understand what they're signing, because the person signing that power of attorney and assigning somebody to be their power of attorney has to have capacity. They have to know what they're signing. They have to understand what they're signing and sign it in front of two witnesses and a notary. And in that power of attorney, I have about I think it's almost a 4-page document, power of attorney, and it lists as much as I absolutely can put in it. And it seems to be growing by the day because banks are requiring it to say certain things. Mortgage companies want to say certain things. So I'm constantly adding to it and constantly just making it grow. But it covers writing checks, dealing with your bank, dealing with your mortgage company, having the ability to hire realtors or attorneys or accountants to do your tax returns, to pay your bills, to talk to Social Security, all of that. And I even add one little line at the end. I think it's number 21 or 22. And it says, and make all healthcare decisions. Now that's where it gets a little tricky there because yes, in a power of attorney, you most certainly can say they can make healthcare decisions. A lot of times I like to separate them. And how I separate them is putting it into a healthcare directive. Now there's two types of healthcare directives. There's one that I draft. I want my brother to make healthcare decisions for me, which would be pretty smart because he's a nurse. Him and his wife are nurses, so that would be very smart to do. But I want to appoint him to make healthcare decisions for me. So what I draft is a healthcare surrogate, where I, of sound mind, am appointing my brother to be my healthcare decision maker only if I'm unable. If I'm able, I can make all the decisions I want. So that's the difference between a power of attorney and a healthcare directive. That healthcare directive doesn't come into play until you're unable to make those decisions, whether you're in a persistent vegetative state, whether you have memory loss, you are unable to speak, whatever it may be, that's when that kicks in. And that individual will now make healthcare decisions for you. I want to emphasize this. Again, you need to speak to the person that is going to be your healthcare surrogate because you want to make sure you're on the same page. You're on the same level. So let's say I talk to my brother, who I'm going to appoint as healthcare surrogate, and I say, listen, I don't want to be hooked up to any machines. When it comes I'm in a terminal condition, no hope of recovery, in a persistent vegetative state, I just want to be kept comfortable. And he goes, oh, no, Laura, I can't do that. I don't believe in that. I want you hooked up to everything alive because I love you so much and I want you to live forever. is that somebody that I want as my healthcare surrogate? Of course not. He's not going to be able to follow what I want. He's not going to follow my wishes. He's going to grow deep inside of him and say, I can't physically do it. I can't do it because it goes against everything I believe. And that's okay. Not everybody believes in the same kind of things. So I would not appoint my brother because we're not on the same page. Otherwise, this is what's going to happen potentially, because there's going to be a healthcare directive and I'm going to have my living will saying what I wanted, and my brother's not going to follow that living will. So I want to make sure that my wishes are taken care of. So maybe I go to my younger brother. He's a CPA. He's very smart with numbers. So he's a little more practical. So he may say, okay, Laura, whatever you want to do, I'll do. So maybe I appoint him because he'll be better able to handle that. So that's what a healthcare surrogate is. Now, if you've done nothing in ways of appointing anybody to make healthcare decisions for you, and you go into the hospital or you go into a rehab facility and you're unable to make these healthcare decisions on your own, the facility, the hospital, or the rehab facility can appoint somebody to be your healthcare proxy. Now, we all know what proxies are, right? We get the stuff in the mail where, oh, you can vote by proxy. What does that mean? That you're not there, that you're doing it on behalf. You're doing it on behalf of yourself. So this is a healthcare proxy, somebody to step in on your behalf to make healthcare decisions for you. And it goes by a succession, at least here in Florida, by a succession of most importance. The top would be your spouse, then any adult children, then your parents and any siblings and any cousins and a friend. It goes all the way down. The very bottom one, if there's absolutely nobody, you have nobody that can make these healthcare decisions. In the state of Florida, they allow facilities to appoint a licensed clinical social worker. That's what I am, as well as an attorney, a licensed clinical social worker, to step in. Now, they have to go through a certain battery of things. They have to be approved by the facility, by their bioethics committee. They have to have ethics committee meetings if life-sustaining or life terminating decisions are made. They can't just make them on their own. But here in Florida, there's that very bottom tier. And I helped write that statute to make sure that licensed clinical social workers were there. So let's review. We talked about a power of attorney. A power of attorney is something I sign appointing somebody to either make healthcare decisions and make all my financial decisions. That goes into effect the millisecond you sign it, and it's witnessed and notarized. So make sure it's somebody that you trust. Then we have a pre-need guardian, which we talked about. I'm putting down in paper, if I ever need a court-appointed guardian, this is who I want to be the guardian. Now, mind you, that guardian doesn't have to agree, but again, I would have that conversation with that person to make sure that they're okay with it. But maybe it doesn't happen until 10 years down the road, and now they're really not in this situation to be able to do that. Then they can look at other means for a guardian, family members or a professional guardian, whatever works. Finally, the healthcare directives. Healthcare surrogate. I'm appointing somebody to make healthcare decisions for me if I'm unable. That would come into effect after I become unable. Or healthcare proxy. That's if I appointed absolutely nobody and now I'm in the hospital or in a rehab facility and they need somebody to make healthcare decisions on my behalf. Again, they look to the statute, they go down the statute. Who is the best person? Who's the one willing to do it? Who can they find? I've actually had the hospital with their private investigator go to a bar and find a friend, because apparently this person, they were told, frequented this bar a lot. And sure enough, they found somebody, a good friend, who was able to step in as a proxy. I know it sounds crazy, but hey, you know, who do we hang around the most? Who do we talk to? You know, if we don't have any family, who do we talk to? Friends, you know, people that we know, and they're going to probably know more about us than some distant cousin who we've never met. So again, power of attorney, pre-need guardian, healthcare surrogate, healthcare proxy. We're here for you. We're in the state of Florida, as I always say. So if you live in another state or another country, please check with the legal in your area, in your part of town, in your state, whatever it may be. But as for Florida, We're here for you. We're here to answer any questions for you. And I hope that this live helped, because this is very important things, especially here in the state of Florida. We just had 2 massive hurricanes wallop Florida, and a lot has happened. And it makes you kind of stop and think about, what would happen if something happened to me, or if I became incapacitated? These documents are important, and they're necessary to make us feel at peace and to make sure our things and stuff in our body are taken care of. Have a great rest of your October, and I'll see you in November.